What happens when a Hollywood good guy brand meets a courtroom buzzsaw, then simply walks away? That's the riddle now haunting Justin Baldoni. Midnight, LA Superior Court. The deadline for Baldoni's second amended complaint against Blake Lively ticks past. No filing. Court clerks refresh their screens. Nothing. At dawn, Brian Friedman, Baldoni's attack dog attorney, releases a cryptic statement. Instead of revising the existing claims, our clients will be pursuing additional legal options. Translation: we threw our entire lawsuit in the shredder, but trust us, something bigger is coming. Or so he hopes. Rewind 3 weeks. Judge Michael Lyman nukes Baldoni's defamation case, dismissing it with prejudice. Legal shorthand for "don't bring this trash back." All that survives is a feeble business interference claim, and even that is on life support. Lyman offers a lifeline. Amend the complaint. Add real facts. Maybe, just maybe, it squeaks past round 2. Brian promises TMZ a robust rewrite. Then silence. Speculation detonates online. Did Baldoni discover he had no evidence? Did he decide the PR beating was worse than defeat? Or is he hiding a Hail Mary appeal? Enter attorneys Ron Zambrano and Christopher Melcher, legal veterans who dissect celebrity lawsuits the way chefs fillet salmon. Their verdict on Popcorn Planet is brutal. Chris, the case was already on life support. They basically pulled the plug. Ron, either they don't have the facts or they'd rather drag Blake through discovery hell than fix limp pleadings. The missing amendment isn't just paperwork. It's Baldoni's last shield against the legal war Blake launched after accusing him of harassment. Without it, he's reduced from accuser to defendant, forced to explain every text, every meeting, every whisper Wayfair executives ever heard. Blake's camp smells blood. Under California's fierce anti-SLAPP statute, victory means attorney fee revenge. Her lawyers will soon submit a tab north of $500,000 every hour they spent dismantling Baldoni's claim, now payable by Justin and Wayfair. Think of it as a defamation boomerang. Could Baldoni still appeal Judge Lyman's dismissal? Technically, yes, but appeals focus on law, not fresh evidence. Lyman's ruling sits on rock-solid precedent. Statements made in anticipation of litigation are immune unless malicious and baseless. Brian never even alleged malice. As Chris warns, blaming the judge for following the statute is wrong-headed. So why abandon the rewrite? Ron offers a darker theory: discovery as bludgeon. By letting Blake's countersuit proceed, Baldoni's team can subpoena diaries, emails, even those rumored Taylor Swift texts Blake allegedly begged to delete. If they unearth a single destroy evidence message, they can detonate it under Blake's case and maybe file malicious prosecution later. It's the litigation equivalent of lighting your own boat to burn the enemy fleet. Yet discovery cuts both ways. Blake's deposition looms postponed, not cancelled. She can stall, but not forever. If she stonewalls, the judge can impose sanctions. If she talks, she risks contradictions. Still, Ron notes, she's holding higher ground. She decimated his suit. Now she controls Meanwhile, fans ask, could Blake simply drop her claims and end the bloodletting? Unlikely. Why surrender when you're inches from a fee award and public vindication? Dropping the case would cost her vindication and let Justin label himself cleared. Pride and legal fees say no. Online narratives fracture. Baldoni stands claim Judge Lyman owns Disney stock. Conflict. Lawyers roll their eyes. Federal judges invest in every blue chip. Correlation isn't bias. Others swear Brian holds a joker card. Deleted text proof Blake orchestrated a smear. But unless that evidence surfaces before appeal deadlines lapse, it's just vapor. So where are we? Baldoni's lawsuit lies in a pauper's grave. Blake's counterstrike marches forward. Somewhere, Brian Friedman plots additional options that sound more like wishful hashtags than strategy. Discovery promises scorched earth, yet Blake can drip-feed compliance, running Justin's costs sky high while the public forgets why they cared. The suspense now hinges on 2 clocks. Fee motion day, when Blake's lawyers present a 6-figure invoice. Justin must explain to Wayfair's shareholders. Deposition day, when Blake sits under oath, cameras banned, transcript bound for leak within hours. If Blake flinches, if a single message proves she weaponized false claims, the narrative flips overnight. If not, Justin's brand of enlightened masculinity could drown under legal fees and an empty courtroom echo. Either way, the amendment window is closed forever. The game board just shrank. The stakes did not. The next move happens under penalty of perjury. 45 days after the missed amendment fiasco, the case lurches back into Judge Lyman's courtroom for the first fee hearing. Blake's lead counsel, a velvet-voiced litigator named Maris Cabrera, pushes a 2-inch binder toward the clerk. The cover reads, Lively v.C., Baldoni et al. Motion for mandatory attorney's fees. Amount requested $728,417. Reporters inhale 700 grand for a complaint that never survived round 1. Wayfair attorneys flinch. Whispers say the company's board has quietly opened a settlement reserve in case Blake's bill tops $1 million. Brian Friedman rises with a practiced sigh. He calls the figure inflated, accuses Cabrera of weaponizing fee statutes, then pivots to a tantalizing tease. Your Honor, we have recently obtained communications suggesting Miss Lively sought to destroy material evidence. The gallery gasps. Judge Lyman lifts an eyebrow. Cabrera's smile doesn't even twitch. Friedman is referencing a new subpoena served on iCloud, targeting a deleted text thread between Blake and an unnamed pop superstar friend. Reddit has already guessed the friend, Taylor Swift, queen of encrypted candles and midnight phone purges. If the messages show Blake ordering a digital bonfire, Friedman can petition for terminating sanctions, legal kryptonite that could nuke Blake's entire suit. Problem: he doesn't have the texts yet. Apple's legal team wants a federal judge to compel, and that hearing sits 3 weeks away. Judge Lyman grants Blake's fees in principle but holds the number in escrow until the spoliation issue is resolved. Friedman buys time. Cabrera buys champagne. Discovery Hell Week. While lawyers duel on paper, depositions finally begin. Day 1. Justin Baldoni sits for 9 hours. Cabrera drills him on the exact timeline of Wayfair's marketing fallout. Justin mentions 6 lost brand deals, but emails reveal only 2. One paused, one under discussion. Cabrera circles exaggeration on her pad. Day 2. Blake Lively enters a windowless room. Soft pink blazer, gaze cold enough to chill coffee. Friedman launches the smear campaign theory, sliding over a blown-up WhatsApp screenshot. His mask will fall off soon. Patience. Blake, that was a private hope, not a strategy. She invokes California's litigation privilege 23 times before lunch. Asked about the Taylor texts, she replies, I don't recall any deletion request. Cabrera objects, cites the pending motion. Across town, Taylor Swift's lawyers file a blistering brief. Our client is a global touring artist, not a vault of irrelevant gossip. Judge Sorkin, overseeing the iCloud subpoena, schedules an emergency hearing. TikTok legal sleuths label it Taylor vs. subpoena. Swifties flood the docket portal until it crashes. The spoliation gambit. Hearing day. Friedman argues the texts could prove coordinated malice. Exactly what Lyman said was missing. Apple's counsel shrugs. Even if they exist, privilege still protects pre-litigation strategy. Judge Sorkin splits the baby. Taylor must submit her device for a forensic scan, but the results stay under seal until he rules on relevance. Twitter splits too. Blake Lively is over party trends. 9 hours then fades when Swift drops an Instagram snippet of a new single, PR Judo at its finest. Inside Lyman's chambers, timelines tighten. He sets trial 10 months out and warns, any party caught withholding evidence will face severe sanctions. Cabrera nods calmly. Friedman scribbles furiously. Behind the scenes, panic. Wayfair's CFO hates open-ended litigation. Analysts downgrade the stock, citing reputation drag from high-profile harassment suit. A board email leaks. Cap fees at $2 million, push for mediation. Baldoni's producing partner grows skittish. A streamer delays greenlighting his next film until the suit stabilizes. Blake, despite momentum, feels tremors. Paparazzi camp outside her kid's school. Sponsored posts stall. A studio exec warns, one coercive text and we distance. The mediation trap. Sunset Beverly Hills penthouse. Retired Judge Ramirez convenes hush-hush mediation. Option A. Baldoni drops counterclaims, pays part of Blake's fees, issues joint statement, misunderstanding resolved. Option B. Blake limits damages to $1, cancels fees if Justin records a PSA on workplace boundary. Option C. Nuclear no deal, discovery vomits into tabloids. Both gamble on scorched earth trial. Talks stretch past midnight. Reporters spot Friedman exiting first, stone-faced. Cabrera leaves an hour later, phone glued to ear. No comment. The paper-thin piece. Morning. A single-sentence joint filing hits the docket. Parties have reached an agreement in principle. Details forthcoming. Speculation detonates again. Did Justin buy peace with a check or a confession? Did Blake trade dollars for silence over those Taylor texts? Neither camp speaks, bound by an NDA thicker than a phone book. But procedure reveals a sliver. 2 weeks later, Judge Lyman dismisses Blake's suit with prejudice. Settled. He vacates her fee motion per private agreement. Translation: money likely changed hands, and not in Blake's direction. Instagram. Justin posts a black and white quote. Peace is the victory no one sees. Comments off. Next day, Blake shares sunset photos. Caption gratitude. No mention of court. Taylor's subpoena. Quietly withdrawn. Fans rage. Lawyers shrug. Insiders whisper. Someone paid. Someone saved face. Everyone lost a chunk of credibility. Because in Hollywood lawfare, victories are rarely public. Truth is always redacted. And the only sure winners are billable hours that keep ticking long after the cameras stop.